one nation, under God, indivisible, with liberty and justice for all.
Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, notice is hereby given that if you're not satisfied with the decision made by the Metropolitan Transportation Licensing Commission, you may appeal the decision by petitioning for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the entry of the Metropolitan Transportation Licensing Commission's decision. We advise that you seek your own independent legal advice to ensure your appeal is filed in a timely manner and that all procedural requirements have been met. Mr. Fields circulated to the Commission ahead of our meeting last month's minutes in draft form. Have the Commissioners had an opportunity to review?
We have.
Is there a motion regarding approval?
So moved. Second.
All those in favor?
Aye.
Motion passes. First item on our agenda is election of TLC officers. Mr. Fields?
Every 2 years in the even year, the commission is asked to reconstitute itself with officers. You have 3 officers of the commission. You have the chair, a vice chair, and you have an executive secretary. I serve in the executive secretary position through appointment by NDOT. But you would need to consider new officers. In the last term, Mr. Hernandez serves as chair and Mr. McNally served as the vice chair. Clearly, it's a matter of nominating whoever would like to do it and then have an election, and then we'll report that to the Metropolitan Clerk, which is the next step.
Mr. Chairman?
Yes.
I would like to nominate Sal Hernandez and Patrick McNally as chair and vice chair to serve an additional term.
Second.
Any discussion? All those in favor?
Aye.
Motion passes. Thank you.
We are welcoming 2 new commissioners today now that that's over. Mr. Trey Relaford has joined the commission through appointment by the mayor, as well as Mr. Keith Powell, who has also joined as appointment to by the mayor and approved Tuesday night at the commission at the Metro Council, so we're certainly glad you're here today. Two of the commissioners also reappointed, Ms. Westlake and Vice Chair McNally.
Thank you, Mr. Fields. We have a few items on the consent agenda today. We've been asked to review other passenger for hire vehicle company applications. Mr. Fields?
In front of you are applications for other passenger vehicles for hire. All of them have completed the application process and provided the information. In order for them to operate, it requires commission approval. I'll be happy to read them into the minutes if you like. Arif Transportation, AWD Transportation LLC, Daniel Limo, Frank Transportation, Ismat's Car Service, Mini Vegas Limos, Ricky Duke, Unison Transportation, Vision Transportation, Zach's Transportation, and Zillion Limo Service.
Mr. Fields, for the benefit of the new commissioners, would you explain what these other passenger vehicle hire, what they're like, and what they do, and why we have so many of them at one time?
I will do that. Other passenger vehicles for hire are covered under Section 6.74 of the Metropolitan Code of Law. This particular section allows for vehicles such as limousines, sedans, black cars, special purpose vehicles, basically things that aren't taxi cabs. So that's what's actually covered under this. So it would also cover shuttles. It's a wide variety of vehicles as far as the numbers. For instance, if you want to operate as an Uber driver, specifically Uber Black, then you would have to actually establish a company as an Uber Black company with a commission in order for Uber to allow you to operate. That's their rules, not ours. So they would come to the commission, they fill out the application, proof of insurance, drivers are vetted through fingerprint background checks, and then we present it to the commission for its consideration.
You have no hesitation about the applications of these various different people?
Based on the
companies?
information provided, they're in order.
I would make a motion that we approve the applications en banc for all the companies that were named by Mr. Fields in the record.
Second.
All those in favor?
Aye.
Motion passes. Next item on our agenda this afternoon, we have a public hearing. Every year, we have a hearing for consideration of horse-drawn carriage certificates of public convenience and necessity to consider any requests for and/or requests for additional carriages. Mr. Fields?
As the chair indicated, in section 12.54 of the Metropolitan Code of Law, you're required to have an annual meeting for consideration of any applications for horse-drawn carriages. This year, we did not have any new companies make application. An existing company, Sugar Creek Carriages, has made application. Would like to have an additional 7 carriages to operate within the metropolitan government area.
All right.
They're represented and they're present.
Great. Aside from hearing from the representatives of Sugar Creek, has anyone requested to speak?
Just one. Ms. Jeanette Barker.
We'll go ahead and hear from Ms. Barker, and then we'll hear from Sugar Creek.
Afternoon, Commissioners. My name is Jeanette Barker. I am speaking today as the VP of Strategic Development with Nashville Downtown Partnership. In this position, I am speaking on behalf of a unified voice of downtown stakeholders, people who live, work, play, and invest in downtown. This is really a recap and a reiteration of a letter that we had sent to the Commission earlier today, co-signed by the Nashville Area Chamber of Commerce as well as the Nashville Convention and Visitors Corporation. Standing together, we 3 entities are asking that the Commission not grant any additional permits at this time. We believe that for several reasons. We know that we've just done great work together, and you all spearheaded the effort to assess the situation with slow-moving vehicles, of which horse-drawn carriages fall under. And there are, of course, safety and congestion and mobility issues associated with that. But perhaps most importantly, what we're really asking for is not just a decline, but we would call it a moratorium, a temporary pause on issuing anything that will be an additional slow-moving vehicle through our busiest corridors, blocking and creating challenges at a minimum in the public right-of-way, specifically because we are in the middle of the Connect Downtown study. Downtown Partnership is a partner and a collaborator in that study with NDOT and WeGo, and we're just in the middle of that very important mobility study and are asking that until that study yields recommendations and findings for issues related to congestion, mobility, and use of our shared public right-of-way, that we just, at a minimum, keep status quo on, particularly on slow-moving vehicles in the downtown core and other areas. Thank you.
Thank you. Mr. Blackburn, I don't want to presume that you're going to be speaking, but it's your Sugar Creek's turn.
Well, Mr. Fields, it's easier to get me started than stopped, so I'll be brief. Given this presentation, I'll cover a couple of things just in the interest of time. I know this is not part of the hearing on the application. First of all, to make a correction, I believe Mr. Fields put the application did say 7. We're not really seeking 7 additional. We're seeking 7 in total, which is only 2 additional. They have 5 now and have had for quite some time. I'm a member of this downtown association. At least I'm invited to attend and show up. My wife and I live downtown. We're not opposed to this, and I've never been asked to take a vote on it. Better Business Bureau, Mr. Fields has a A+ rating with a, not Mr. Fields, excuse me. You might, you would deserve it, but Sugar Creek has an A+ rating with Better Business Bureau. It's never been sued, never had any issues at all. Those of you who have been here a while will recall that we went through a long period of let's say, discord We used to call them the carriage wars. That doesn't exist any longer. Now there is only one company downtown, and that's Sugar Creek. There were 18 permits that have been issued. Some of those perhaps are not currently active, but no other company is providing carriage services downtown now except for Sugar Creek. So there are 5 now, not 18. Now, I think the interesting thing here is the evolution of the downtown entertainment district. Certainly during my lifetime, I'm about to get the 50-year award, which I call participation trophy, with the Nashville Bar. I can tell you 50 years ago when I started practicing law, Lower Broad was sketchy. Lower Broad was not a place you'd want to go to at night unless you had certain inappropriate desires. We now have what Keel Hunt calls a downtown that is basically like a theme park. This theme park has been dedicated to adults, bridesmaids, consuming alcohol. What's left for families? Sugar Creek. The only entity providing this sort of amusement, if you wish to call it that, downtown is Sugar Creek Carriages. They're the ones with the families and with the children. We had, when we get to that part here, we have a very brief video which we played a year ago because there are a number of persons here who are new on the commission. We'd like to have your permission to play it very briefly so you can see vividly what the problems are. Problems is that there are not enough carriages operating to meet the demand of families, not bridesmaids, not people who ride around and sing and cause the disruption, but families. And that's the Sugar Creek clientele. Also, something that has happened is through cooperation with the state of Tennessee, Sugar Creek provides tours at the downtown, not merely downtown, but at the Bicentennial Mall. That's a very popular tour. You might have 2 carriages at a time who are at the downtown mall, the Bicentennial Mall. So also the ideas of traffic, you should keep in mind that already carriages and others are not allowed to operate in the peak hours, that is between 4 and 6 p.m. So you have a form of amusement or entertainment or whatever we wish to call it that's been available for 20 years here. Only now there's not enough service to meet the demand. This wasn't raised this time, but the last time we had this, there was some question about whether these horses or mules cause, let's say, some disruption by their biological needs. There are more police horses downtown than carriage horses. They have the same needs, but they're not attended to in the same way. And I don't want to be unpleasant here, but we have homeless people downtown who are a much bigger threat, it's the wrong word, challenge, than horses who are well taken care of and whose issues are dealt with. So what do we have? We have something that's wholesome, something that does not involve alcohol, something that does not have 20-something women yelling and singing, as entertaining as that sometimes can be and as annoying as it mostly is. We don't have that. We have decent people riding decent people to pleasant things that are wholesome. There's a place for that in Nashville. There's a place for that in Nashville. And now we've gone from 18 permits and lots of controversy to 5 and none, and some of those are diverted to the Bicentennial Mall. So I would suggest to you that we have to look at Lower Broad and that area as something more than a theme park for youngsters. There's other people who need this as well. Thank you.
Is there anyone else who would like to speak on the issue of whether or not to grant any additional carriage permits? You want to speak? If you'll step to the mic and introduce yourself.
Sir, my name is Dallas Lancaster. I work for Sugar Creek Carriages. We have an abundance of customers who come to us, very large quantities. As it said, we don't have the amount of people that we need to drive these customers where they would like to be escorted through town to see our city, to see what we come from, to see what we're about. I know for hands-on experiences that people really enjoy us being here. They do wait lengths amount of time that are quite large and extensive most of the time due to the lack of drivers that we have, but they do stay and they are diligent and they are in a great mood and they're happy for us to be down there because there's not many things for us to do down there other than, as we were told earlier, and we all know that there's a lot of people down there. There's not many places you can take a family or children or anything else inside other than adults. So I really do think that we could really use and do need more drivers. So we do need the permits. It helps us out. It helps y'all out. It helps us all grow closer together. It keeps us on the map on a historical amount. And on a historical amount here in the town of Nashville. You know, that's what we were built on is the ways as it was, and we're falling far behind.
You'd mentioned, or Mr. Blackburn mentioned, that you've got about 2 carriages that are dedicated to the Bicentennial Mall area.
Yes, sir. That's a 2-hour ride.
And that's every day?
Yes, sir.
And then that, I presume then your other 3 are in the downtown area?
Yes, sir.
Have y'all considered limiting your request to 2 additional permits, but having to have those 2 additional dedicated to the Bicentennial Mall area? Yes.
I did actually think of doing that, but the problem is the people that want to do this are on Lower Broadway. The reason that I originally introduced the 2-hour historical ride mostly was historical value, Nashville, because it's great. There's a lot of historical value here. And also to alleviate the amount of traffic that's on Lower Broadway, because there's a lot of traffic issues there, as we know. And I wanted to start expanding out, getting the carriages and the people away, and that was part of me doing that. But as far as dedicating the 2 carriages out there, it wouldn't work. And I went over that with Mr. Fields before I even seek permission to get from Mr. Wooten out at the director out there at the mall to be able to do this. The pickup point needs to be where we're already at. Then we can get the carriages out over there. So that's what it is.
Go First Avenue out there.
Yeah, we go First Avenue. We go First Avenue or Second Avenue, because Fort Nashville's on First Avenue, or Second Avenue. That's historical buildings there with selling the retail products off of the docks way back when they'd bring it out on Second Avenue retail. And we go up Printer's Alley by the Capitol War Memorial Building, the whole historical thing of that. And what that does is worse than it was last summer. If you remember that video, there was a lot of people and they was getting upset because they had to wait for an hour or more at a time to get on a carriage. And we had families sitting there waiting. Now it's even worse because the carriages ain't there. They're gone for 2 hours. So it's just, we need at least 2 more carriages to be able to handle the diversity of Bicentennial Mall and everything we're doing. That's just what we need.
Thank you.
Yes, sir.
At this point in time, we'll close the public hearing. Oh, I'm sorry, I missed your hand. We will not close the hearing if you'd like to speak.
She fell off a horse. No, I'm not. That's what happened.
All right, So I'm Whitney. I'm the manager of Sugar Creek Carriages. I'm one of the main ones that does the 2-hour tour. It does start on Broadway, as Johnny mentioned before. It's an impulse buy, so it's important that we are in the downtown area. And we kind of weave about throughout the downtown area within our zone, and then we go over to Bicentennial Mall Park. It's actually one of my favorite rides. But it does tie up me for at least 2 hours. And as Dallas said, and you will see in the video, people sit and they will wait for a long time. But 2 hours is just a little bit too much to ask, for people to sit and wait. So we definitely need more. And thanks to, Billy Fields and Jerry Wooten over at Bicentennial Mall Park, we were able to get that contract. And I love it. I would love to continue doing it. It does preserve the history of, Nashville. And I don't know how many of you actually drive in the downtown area, but if you drive for a living down there, people just pass us. We don't really stop up the traffic, and like where it's blocked off on First, when you're headed up north, we're small enough that the cars can actually just go right around us. And it doesn't actually impede traffic the way that, say taxis, Ubers, Lyfts do, loading and unloading in the middle of the streets. So I thank you guys for your time listening to us today. You guys got any questions?
I have one.
Yeah.
During the winter months, do you find the number of people requesting rides to be fewer?
Yeah, at times.
All right. And when does that pick back up in the spring?
Well, Valentine's week, we're crazy busy with reservations, and it gradually increases from there until people really start vacationing. And then we're full swing through the end of the year. December is crazy busy with Christmas light tours.
So there's some weekends when there's peak numbers during the holidays and Valentine's, and then for the winter, for the most part, it's lesser number of people.
I don't want to say it's necessarily always less, because I've been here 3 years now, but I will say it's hit or miss. Sometimes it's weather dependent, and obviously how the economy's doing. If people have more money to, more disposable income to spend on doing the carriages. And I will say, Johnny told me this. Carriages were brought in here 40 years ago to help clean up the image of Nashville. It is a family-oriented thing that people can do instead of the bars and stuff, and something, traditional and educational for the kids. So we'd like to preserve that and put that out in the public as much as possible. It's a good view for Nashville.
I heard you mention that there's people who wait an hour or 2 hours sometimes. Is that still currently an issue?
Yes, absolutely, because we
Now,
offer...
My next question is,
Okay.
you also take reservations?
Yes.
All right. So how does that balance between people who have made reservations and walk-up customers who simply have to be told, sorry, we got folks with reservations that are ahead of you?
Well, we just have to let them know, hey, we have reservations, X, Y, and Z. You can come back, but then we'll lose that customer because it's first come, first serve around our reservation schedule. So if they are sitting there, they're waiting, they get that information, and then they leave and they come back, then someone else in the line has already come. So then we lose that.
People making reservations online or by calling in?
They can only make them online.
Okay.
Yeah, it's a mixture of both. But the
you
reservation...
may have reservations that are already filling up your carriages, and walk-up people who, like I've done this myself. I'm walking down there, and one of my kids said, hey, let's go on a carriage ride. So we walk up, but we may get told that, I'm sorry, we've got reservations already, so we can't take you today, or it'll be a couple hours.
You might, but the majority of our rides that are sold are walk-ups. Yes.
Thank you.
Thank you.
Mr. Chairman, may I make one more observation that really has more to do with this hearing, the public hearing rather than the application. Sugar Creek Carriages has W-2 employees, not independent contractors. They have workers' comp coverage. Presently, they are, how shall I put it, under siege by the Department of Revenue to pay taxes, pay sales taxes. There's a legal question as to whether the department has the authority to tax an amusement as opposed to a place of amusement, and that'll ultimately be decided by the Court of Appeals. But that is the legal issue involved in that. The point being that I don't believe other carriage entities in the past have done that, have applied all of these customary laws. And a former competitor works now entirely at Opryland Hotel, and I think all the taxes, all of that is handled through the hotel, and they just are contracted to provide the service. I would suggest that the appropriate time, and this is not it, the appropriate time that the requirement be extended to any carriage entity that wanted to operate downtown, that they have to treat their employees as employees. You may recall, Mr. Chairman, we went through this one time, and I went through the statute, and all the indications of employee applied as opposed to independent contractor. Sugar Creek is complying with that now, voluntarily, and for a number of years. I just wanted to point that out.
Go ahead.
Question. Mr. McNally, you was stating, you was wondering about the customers that does walk-ups that we have to turn down because we have reservations. I wanted you to know, these people get upset because of that. I've had several times that have with Whitney that they get upset. And that's part of me wanting more of these because, you know, I'm sitting here telling my drivers are sitting here telling customers that we got to take this reservation because we don't have enough carriages, and they've been already sitting waiting for 30 minutes just to be able to get to talk to someone. So they get upset.
Well, it might become a third factor on the consideration of keeping the peace downtown.
Yes, sir.
Thank you.
All right, well, thank you. At this point, we'll close the, yes.
Are there,
You have a question for
I do.
Mr. Blackburn?
yeah, just relative to the, your pickup, where is your pickup downtown?
It's right in front of the Hard Rock Hotel. I'm sorry, Hard Rock Cafe on the corner of Broad and First.
And is there a booth or a sign or how?
We put, the city provides us with a carriage stand and also the taxis. And they're our allies. We get along great with them. We share the stand, designated carriage stand and a taxi stand.
That's on the pole.
I believe, Mr. Hayes, that is established by Metro, not by the commission. Is that correct, Mr. Fields?
Correct.
Traffic and
The
parking.
Traffic and Park Commission
And
establishes that.
in years past, there was controversy over the use of those and who got to use them. That's no longer really an issue. But they are at an assigned place during assigned times.
Can the sign reservation only? Is there a way to change the marketing on the sign so that you don't get into the fight of customers and have a website or any other address? No.
I don't, if I can answer that, Johnny, I don't think that we, as a company, can create signage contrary to the Metro rules. These are done by Metro and not by us. Although I think that might have some utility to it. I don't think it's a bad idea. I just don't think we have the power to do it.
Blackburn, I wanted to ask a question. If you were given 2 more carriages, is it the intent of Sugar Creek to have all the carriages out there at one time, or is it a situation where 2 would be in the paddock waiting to come out if one of them broke down or not? I mean,
Can you
is
answer that,
the
Mr.
intention
Smith?
to be using them all the time?
I really couldn't have the horses or the drivers, just waiting at the paddocks or waiting to see how busy we would become.
So the intention is to have them out there.
Yes,
Now,
but
is there room at the loading dock for 7 carriages? I remember when we had controversies with the other carriages about whether the tail went first or the nose went first and who was on first and who was on second. Is there actually room there at that loading dock for 7 carriages and horses?
Yes, we still have the carriage stand available to us along First Avenue. So there's actually enough room for, I'd say, maybe 12 carriages in total. But we have the whole First Avenue right there in front of Union Station where they've authorized us to get water, by the way. a great help to us. But we have that whole area right there to park the carriages, and then 2 over in front of the Hard Rock, and then 2 taxis are right in front of us, and we share that part. But they would take turns pulling up, you know.
Also, because they're in use, you would not have all 7 there at one time at any event.
You might at the start, though.
They're in circulation. Yeah, maybe at the kickoff.
I just remember the problem we had with carriages taking over parking spots or placed here and there. So,
That was,
all right.
that
Thank
was
you.
I know exactly what you're talking about. That was a competition issue because they weren't supposed to, it's against the rules to take on a ride in the middle of the street. It's against the rules for the taxis, but they do it anyway. But at any rate, that had to do with who got the ride and not room specifically. And they were complaining because somebody would come in and sit there too long, and then it queued up carriages behind there. But that's when we had 18 permits.
As I look at this application, the application was for 7 additional carriages, but that has changed now. We're thinking about 2.
We're seeking 2 today. Yes, ma'am.
Okay. Okay. Thank you.
Mr. Chairman,
Yes.
you mentioned that the majority of the passengers that ride do so on an impulse buy and use that as an indication of demand. And my question for you is, have you done any type of study or kind of have any numbers that would indicate how many additional passengers these 2 additional permits would allow you to have, and what kind of revenue that would generate, or any type of information as to what these 2 additional permits would do for meeting that demand?
I haven't done a study for this year, but I did do the study last year, and the only reason I didn't do that study for this year is because it simply got worse, because we implemented the 2-hour ride. So it wouldn't change. I mean, if I had 7 carriages down there, sir, they would, the amount of money and work would be the same. It would be pretty much nonstop, with including our 10-minute breaks on the hour, and our time we have to wait for the reservations to come up. So it wouldn't change a bit. We would still, and we can also kind of regulate how many carriages are there by how many reservations we have on that weekend, and that way we've got a pretty good idea if I need to have 4 carriages out, or if I need to have 7 for this busy weekend coming up. So I can regulate, and I do that, as a matter of fact, because there is weekends that will be slow, especially, you know, after December through till about the 1st of March. It'll be kind of slow in that time, but I regulate it that way.
Thank you.
I hope that helped you.
And Mr. Lancaster, who spoke a minute ago, has told me this morning, or this afternoon, excuse me, that he's had as many as 75 customers turned away in an hour. And he'll offer that, if need be, at the other part of the hearing.
Mr. Chairman, and I think you were at the place of ending the public hearing. We also have NDOT staff present, our planning manager? Our chief planner at NDOT is present to discuss the Connect Downtown study. I'll also tell you, and I was unable to print them because they came in late, you do have 2 letters that are that were emailed to each commissioner prior to the meeting. One from the Downtown Partnership and the other from the Convention and Visitors Corporation. But it is in your email, and again, it came in so late I was unable to print it to submit it. But we will certainly, with your permission, add that as part of the record.
Right. You will certainly consider those part of the record.
And you did hear from a representative from the CVC. But Mr. Marty Sewell is present. If the public hearing portion is over, then if you'd like to hear from him, an update on Connect.
All right, we'll do that. So at this time, we'll close the public hearing.
Good afternoon. I'm getting my presentation set up over there, it looks like. Again, I'm Marty Sewell with NDOT, and I'll just give you a brief overview of where we are right now in the process for Connect Downtown. But just basically to set us up, the The purpose of Connect Downtown is for us to come to grips with our congestion in downtown and looking at ways to improve it through traffic operations and curbside access, transit connectivity, and pedestrian and bike safety, and ultimately to develop a plan that can fund and implement, that can solve and serve downtown's mobility needs across the board. Just very high level, the goals that are set right now, and I'll give you a place where you can go to look at these in more detail in just a second. But these are the 6 main driving goals, and I won't repeat all of them, but go ahead and go to the next slide, please. Just to give you an indication of the engagement we've had to date, we've had multiple public meetings, over 2,500 surveys in a round 1. We're currently in a round 2 of collecting survey information right now. Multiple festivals and pop-ups and whatnot. So we've had a lot of coverage over the area, and so if you've not heard about it, or if you find yourself speaking with someone somewhere down the line where they're not familiar with it, please help us spread that word and make more people aware of what's going on, because it is an important study, as we indicated. Some of the recent activities, we've completed the definition of the goals and vision, desired outcomes, and that's leading us into the next phase of the study. But part of that first bullet, though, was the publishing of the Nashville State of Downtown Mobility Report. That's available on our website for the project, connectdowntown.nashville.gov is the website, and you can go there and see the entire report. And again, that includes all of the vision, the goals, and it sets up where we're headed as we move forward in the next steps on the study. So if you go to the next slide. The main key focus points right now that we're looking at as we move into the next stage and getting more in detail are listed here in this top 8, but I emphasize the top 3 there, the establishing a modal hierarchy for each street, expanding the active mobility networks, and prioritizing transit. That's important, obviously, because of the way of using the curb space that you all have been speaking about tonight with the carriages and other activities that you govern here at this commission. Go on to the next slide, please. There, you can get an idea of one of those, the transit priority corridor. This is an important part of the transit connection in downtown. The idea of being able to create a direct shot between the proposed Sobro Transit Center, which is in the vicinity of 5th and 4th and Lafayette, and connecting that with our current Music City Central in downtown, so that we could have a transit lane or other types of improvements that would help facilitate a faster ride between those 2 locations, because that is a huge bottleneck right now for the transit across the board and slows down the entire network. So pointing that out because we're looking at the options for those transit priority corridors. And as you can see on this map with the purple lines, we're looking at a lot of the streets. And so the point here being that we're still taking a look and analyzing each of these corridors and all of the information that we've collected, working with the community. And if you could go on to the next slide there. Multiple alignments, for example, that we're looking at for the transit priority corridor. Those are all still under examination right now, but we do hope to, over the next couple of months, narrow that down and start creating scenarios that can be tested and modeled and create a final list of projects. But this is just, again, to give the indication to you that we are still looking at each individual corridor and the curb space along each one. And so it is important for us to leave our options on the table, at least for a few more months, as the team working on this project and the community we're working with continue to move forward on it. Let's see, did I have a last slide there? Oh, yeah. And I believe that's all. And if there are any questions, I'm happy to address any of those. I know the director is here too. If there's anything that she or any of the others in the audience could answer, we'd be happy to.
I have a question. What do I got to put? Oh, you're okay. I don't know exactly what you're considering in the study, but I know in other cities, both in this country and around the world, they're closing some streets to cars. So they're more open for pedestrians, bicyclists, and I guess even horses. Is that part of the considerations in the study?
Everything's on the table. We're looking at each corridor, looking at the mode that should be prioritized most on each corridor. For example, some might be transit, others might be pedestrian, and it looks like Diana might want to add.
I had a feeling she would. You said, one minute, you said modal hierarchy.
Yes, sir.
In a lot of the places this is done, the first transport is the pedestrians at the top of that hierarchy. Is that true in your study?
So let me speak to that if I could, Mr. Chair. We did rank transit as the top priority. What really kicked off this study was the fact that it was taking our transit sometimes as much as 45 minutes to get outside of downtown and away from the center where they currently operated, their transition center, the transit hubs. I like to call them mobility hubs, so I still get that confused. But we were really challenged with being able to move our transit operations. So we did make that the top priority, followed by pedestrian, bicycles, and then the vehicular traffic being last.
One comment, if I was a pedestrian, I'd rather share the street with a horse than a car or a truck. It's not relevant necessarily to our discussion today, but that would be my choice.
All right, at this time, as a commission, we should deliberate to answer the initial question of whether there's a need and or public convenience and necessity to grant additional permits at this point.
So our standard is whether there's a public necessity and convenience to add 2 additional horse carriages. That's the question today.
Yes.
How many years has it been since we've added any carriages? There's been several years where there were no requests. Is that right, Mr. Fields?
We've had requests. We haven't added any. I don't have the minute book with me to go back and research. It's been several years since we went through a period where several companies were added, or a couple of companies was added, and they're no longer in business.
Is it fair to say we're balancing Sugar Creek's obvious customers they're not able to service, who probably fall under the public necessity or least convenience, against the concerns that Downtown Partnership and others about the congestion downtown? Is that what it kind of comes down to today?
I think so. Sugar Creek's stated a couple of times that there are 18 outstanding permits today. Is that right?
They're not. Once they're void, the ordinance, they're all void when they're turned in or not renewed, they're void. So they don't actually exist.
So we only have 5.
We have actually 9. 4 are not.
4 at Opryland?
We have 2 companies with a total of 9 permits. The other company operates exclusively at the Opryland facility at Opryland.
Is that a condition to their permits, so they're not able to come downtown, or could they come back down?
They could come downtown.
Okay.
They basically have developed a relationship with Opryland for service out there, because all of the streets at Opryland are actually private streets, with the exception of McGavock Pike going the entryway into Opryland. And I think the other issue that NDOT brought was also the issue of the Connect Downtown, and the fact that the study is just not complete yet. So we're trying to get and I'm certainly not the expert on, if I may, might defer back on.
Maybe a moratorium on any new slow-moving vehicles.
Back in April and May, you actually took that up as an issue and say you basically accepted what NDOT had requested to not make changes to the curbs downtown. And I defer to Ms. Alarcon, if with your permission.
Yes, thank you very much. We did come and ask if y'all would consider putting a moratorium on adding any new slow-moving vehicles in the downtown area, study area that was ongoing as part of Connect Downtown until we complete it and bring it back before y'all. We are looking to get on your March agenda with an outcome and presentation of the Connect Downtown and what the recommendations will be to move it forward. So we would perhaps ask that you consider maintaining that moratorium, perhaps defer this item so it can be considered after we provide the presentation, if at that time we feel like the streets can handle additional carriages or slow-moving vehicles on the roadway. So thank you for that consideration.
The one possibility is we could defer any action on the request by Sugar Creek until after we have your report, and then, so they wouldn't have to wait till November of next year, of 2023.
I had not thought of that, but clearly you could defer and place it back on. In fact, at the end of another business, I have another request to make another change to your calendar for next year. So you certainly could, you've had your public hearing, and then you could then ask Sugar Creek to, any additional information you'd like to have then, and defer it till April or May, or a date, whatever date you'd like to have it, or just defer it and then come back and say, we want to hear it on this day. You could have a date certain, or just request staff to keep it available for you to bring back.
Mr. Chairman,
Yes.
is there a dedicated route where these carriages participate? I know the young lady said that she stays in her zone. Is there flexibility in the route that they can take within the downtown corridor?
I believe there are certain areas they have to stick to.
We've actually tried routes many times, and we actually have had them approved, and then we've had them changed. One of the great problems was construction. So we'd have a street open, then it was closed. So we then basically said, for instance, they can't be on John Lewis Way in the vicinity of Broadway back to KVB because of cobblestones. Horses, the shoes will break the cobblestones, so they do not operate on that particular part. So. And I don't operate the company, but I think the reality of it is they move within a general area of the river up to 8th, from KVB back up to really James Robertson, and we've allowed them to go into the Bicentennial Mall. And we did work a lot with them to give that as an option, which would help alleviate some of the congestion downtown to be able to go to Bicentennial Mall.
I just wanted to say that I was really encouraged by the fact that you were creatively trying to solve a problem, both about congestion and being able to serve customers, and that this, and being creative about moving some of the carriages to the Bicentennial Mall. And thank you, Mr. Fields, for working with them on that, because I think that really shows their dedication to trying to be a responsible citizen downtown.
Historically, we have studied a whole lot of things about horses and carriages, from everything, what's a gallop, what's a walk, and anything in between, including, I remember the days of the horseshoes, whether they should be shoed or not shoed, or booted, so, just to kind of, I would make a motion that we would defer a decision on Sugar Creek's application till May or June meetings.
Second.
All those in favor?
Aye.
Any nays? Motion passes.
I will say I'm very pleased to hear that the carriages are serving families and children, and bringing that component to downtown as well.
All right, well, thank you very much. The next item on our agenda, we've been asked to review and reconsider the entertainment transportation rules regarding enclosure and then the enclosure requirement compliance deadline. Mr. Fields?
As you will recall, at your meeting in October, you had a public hearing regarding, aimed at the companies, but it's clearly a public hearing, to hear progress and process of the companies as they become enclosed. You'll also recall that we are currently enjoined by the Chancery Court of enforcing two sections of our rules, one involving enclosure, the other in the liquor liability insurance. The liquor liability insurance you postponed indefinitely, so it is basically off the agenda until which time we're able to find more information and additional work on enclosure. You basically did not take action, and asked to come back to this meeting. So we do have a representative from Metro Legal that might be able to offer insight to where that issue is, but also looking to the commission. Clearly, the commission's position has been that all vehicles should be enclosed. We cannot enclose at the present time. We are, again, not speaking for Metro Legal, defending in court and plan to. So again, they're available to speak on the issue. Andrew McClanahan is our lead lawyer on the project.
Mr. McClanahan?
Good afternoon. So currently, I think as Billy mentioned, the Chancery Court has put an injunction on enforcement of the enclosure provision. I'm not sure, Billy, what you wanted me to speak to exactly.
Just really an update to that. If the commission wanted to establish a date, whether it's a date certain or a date of months or period, we certainly are respectful of the court and the court's authority over this commission, and we do not want to do anything that would cause any confusion or problems that we might have with a lawsuit. But if the commission wanted to take a position to say, take action at a time in which the chancellor makes a decision, would that be within their authority? I mean, would that be an issue from your standpoint, or would it be an issue from your standpoint? In other words, if they wanted to take a position of when you might enclose based on when the chancellor rules?
Yeah, I think what I would like to know is if we were to amend our previous regulation to say something in the nature of that should the injunction be lifted, that the units would have, say, up to 8 months to get in compliance, would that wouldn't violate anything at this time, would it?
Well, I think currently the enforcement of the enclosure provision is enjoined by the Chancery Court. Part of what was mentioned in the court's order is that there wasn't any consideration given to the time to comply with those requirements by the businesses. And if this body were to further consider that element of it and then pass something today that gave more time to comply and took into consideration that ultimately lifting of the injunction would have to take place, I think that's certainly something that this body could do.
Well, we had a public hearing at our last meeting, and we listened to the owners and the operators of the entertainment transportation units. It sounded like that most of them, some of them are already in compliance. And then some of them said it would take them 8 months to get, I think most of the complaints were about compressors.
And I'm prepared to speak to that if the commission would like. We have 24 companies that are approved as either a ET company or a seated sightseeing or a combination. Out of the companies, there are basically 17 that are one or the other. There are 7 that are straight sightseeing and 17 that would either be ET or ETS as we've designated them on the street. Out of those companies, 12 of the 17 are in one stage or another of enclosure, either full enclosure of all their vehicles or enclosure of, like, one company has one vehicle's already enclosed, the other one is partially enclosed or ready to be enclosed. There are about 5 that do not appear to be enclosed. But again, out of that 5, there are a couple that, if you go and look at the vehicles, you can see where the holes have been drilled in the sides and or modifications made for enclosure. So a large group of the vehicles or the companies are ready to if the chancellor rules that they can be enclosed and we can enforce it, that they're prepared to be enclosed. The other side of it, in the wintertime, even those that oppose enclosure are enclosing or they won't operate because it's too cold to be on the street.
During the public hearing, am I correct when I heard many of them who are not enclosed yet said it would be about 8 months to get the compressors and some of the other things they needed in order to get in compliance?
My memory is, did you recollect correctly, that there were several companies that said it's about 8 months. And some that said it was 8 months because I did mine early. I've got them. Here they are, and they're enclosed now.
I agree with where you're going, Mr. McNally, that in order for the companies to not have to try to anticipate when that start date might begin, it makes sense that if we do reconsider the compliance deadline, that it begin at a time that the court lifts the injunction. And at that point, then carry out 6, 7, 8 months, or however long we believe it's going to be needed. And if we did hear approximately 8 months at the meeting last month.
And I think we also took in consideration the expense that was associated with getting in compliance. We listened to the owners about the expense and the amount of time. So.
I apologize. Could you repeat that question, please?
It wasn't a question, it was just an
Oh,
observation.
well, when you looked at me, I thought, was he asking me a question? I apologize.
Take the eye off the ball there for a moment, Bill.
It was the lifesaver. I apologize.
Well, given that we had a deadline, it is moot because it's passed and we have an injunction. I mean, I think it makes sense for us to consider some sort of a timeline if and when we're able to enforce that regulation again.
I think we start with having to make a motion to amend our previous regulation. Is that correct? Metro Legal?
Correct.
Amend the deadline, you mean?
Yes.
Yes.
Well, Mr. Chairman, I would think with this, with the status of the ongoing legal action, being a lawyer myself and thinking about how these things kind of matriculate and move through, I would think that whatever timeline that we would pick, we would want to make sure that it's one reasonable, but that would flow from the point in time that the injunction was lifted. And so what I think I would do here, given the feedback that we received from the business owners in terms of the time that they would need to retrofit or order parts or do that, and being that time frame has been repeatedly said somewhere between 6 to 8 months, what I would suggest that we do and what I would move to do is have that period of time, I guess 6 months from the period after the injunction would be lifted, that they would have time to then comply with that request. You know, defer to some of my more senior members on the commission in terms of how to appropriately style that to make sure that everything's on the up and up, since this is my first meeting.
The only suggestion I would have is because we heard so many people talk about 8 months, that instead of 6, maybe 8 months from the time, if the injunction is lifted, from the time that the injunction is lifted.
I would be fine with that as well.
Okay. I'll second that motion.
Any further discussion before we vote?
If I may, just to make sure, to restate, it's a motion to require enclosure 8 months from the period that the injunction is lifted by the chancellor.
Yes, and I can restate it. I move to require enclosure 8 months from the period in which the chancellor lifts the injunction, and that legal proceeding is through there.
I'll second that motion.
All those in favor?
Aye.
Motion passes. Thank you, Mr. McClanahan. Next item on our agenda, we've got some disciplinary hearings. The first is for Nashville Party Barge LLC for violation of 6.77.090. Mr. Fields?
Party Barge has, following an investigation of the Tennessee Alcoholic Beverage Commission, one of their employees was charged with several violations of state law. I will not go through that. We do have the agent present. I've asked Metro Legal, represented through Tara Ladd, to be present to be able to describe to you the issue and what's gotten them to where we are today. But as a violation, I mean, in short, it's a violation of a couple of sections, but in particular the section of the alcohol on board that's being sold in 6.77240 as well as 090. So again, I'll defer back to Ms. Ladd to be able to present our complaint that we brought.
So what we'll be looking for today and the two violations that have been alleged, first there's two state law violations that have been alleged, and I think that you received in your packet a copy of the warrant. So it should be a front and back. So on the front and on the back, there's two different statute violations of law that's being alleged, 39-17-702, and then on the other side, 57-3-401 sub A. So you're looking at, one of them is going to be for untaxed transportation of an alcoholic beverage. That will be 57-3-401. And then on the other side would be sale of alcoholic beverage, 39-17-702. And then you have the allegations there from Prosecutor Thornton Vaughn, who's here today if you guys have questions for him. He's special agent. The other, when you switching gears, we'll look at the Metro Code. And the Metro Code, we're looking at two violations. One will be 6.77240, which is serving that alcohol on the entertainment transportation vehicle. And then there's 6.77090, which is violation of any state law as grounds for disciplinary action against the certificate holder. And I'm happy to read any of those statutes or any of those code provisions that you want me to read when the time comes. And of course, anything or any questions that you have concerning the applicability, please let me know.
And Party Barge is present and represented by attorneys.
677.02.0 was
240.
240,
6.77240, alcohol in an entertainment transportation vehicle. And so sub A, let me just go ahead and get it out of the way. Sub A says a certificate holder or driver commits an offense if he or she provides beer, ale, wine, or other alcoholic beverage to a passenger for a fee or as part of the passenger transport service. Subsection B says the certificate holder or entertainment transportation vehicle driver commits a violation of this chapter if he or she provides or stocks or holds on the vehicle beer, ale, wine, or other alcoholic beverage in the ET vehicle, except to the extent otherwise permitted by the beer board. Then you have C, the consumption of beer, ale, wine, or other alcoholic beverages upon or within an entertainment transportation vehicle is strictly prohibited, except to the extent otherwise permitted by the MTLC and the Metropolitan Beer Board. And when it says, when you see those references to Metropolitan Beer Board, that would mean, permitted by the Metropolitan Beer Board. The last one is subsection D, which is unlawful for any person driving or in any way operating an entertainment transportation vehicle to knowingly allow a passenger or staff to consume alcoholic beverages in violation of the Beer Board or MTLC rules and regulations. For purposes of this subsection, knowingly allow means the person has actual notice of or through reasonable due diligence should know that a passenger is consuming an alcoholic beverage or beer upon or which the entertainment, upon or within the entertainment transportation vehicle. So most of the allegations that you're going to find are going to be in the affidavit that was given out to you that is attested to by Prosecutor Thornton Vaughn. I did speak with the Party Barge's attorneys, and they have a presentation for you guys today. We are not going to put on evidence, and they can explain why once they come up. But if you need anything further from me, just let me know.
Is Detective Paul Davis here today?
He is not.
Yes.
Good afternoon. I'm Jonathan Farmer, Chase fan. My partner and I represent Nashville Party Barge. Their principal is Miss Susan Pizzatola, and she is here as well. This is my first time appearing before this commission, so to the new commissioners, we'll get through it together. The Metro legal attorney talked about not wanting to make a presentation. We discussed with her, we are not disputing the allegations in the affidavits as they are, in the sense that the allegations accuse Mr. Robert Pizzatola, a then employee of Nashville Party Barge, of doing the things that he did. And as a result of that, we're not disputing that Nashville Party Barge violated the Metro Code policies. I think what we're here to talk about today, what I want to talk about is kind of where do we go from here? And so what do we do with this? And so I want to talk first about my client. Nashville Party Barge as an entity has been in existence since the beginning. My understanding is that it is the first party barge that operated in Nashville, Tennessee. Around 2015, around 2019, Ms. Susan Pizzatola, through her LLC, that she is the sole member, bought Nashville Party Barge and has been running it ever since. Ms. Pizzatola is not a stranger, I don't think, to this commission, certainly not to Mr. Fields. She operates pedal taverns and the like. I think it's important for this commission to know that this is a family-owned business and a family-run company. Her husband, who I think was at the center of this, Mr. Bob Pizzatola, that's her husband, and she also employs her daughters. Nashville Party Barge employs 23 people, or at least did prior to this. And notably, it's a veteran-owned business. Both Robert Pizzatola and Susan are honorably discharged members of the Army. I think the commission probably knows all too well, and just sitting through the portion of this meeting that I've sat through, it sounds like the regulations regarding these pedal taverns and party barges, since I guess they burst on the scene around 2015, the city's tried to catch up and then maybe caught up and enacted regulations that have evolved and kind of we have where we are now. And I want to point out that Nashville Party Barge, throughout its existence, and certainly since Ms. Pizzatola has run it, has actively complied with and partnered with the city regarding these regulations. And these are difficult and expensive to do. By way of example, in October of 21, and I believe this is germane to the discussion that Commissioner McNally just had with Mr. Fields about the enclosures, Nashville Party Barge spent $105,000 to buy new buses for the enclosures. This is in October of 2021. Also germane to that discussion, in April of 2022, Nashville Party Barge was the second company to actually submit their application. So they got their buses ready, they got them enclosed, and they submitted the application, I understand, in April of 2022. So they're not one of these companies saying, look, I can't figure this out, I can't do it. They want to get in, they want to do it, they want to help. In May of 22, they spent more money, somewhere in the $50,000 range, to retrofit existing buses, and then in June of 2022, they appeared before this commission and awarded 4 permits. This is notable because what the committee has to look at when deciding who gets these permits are a lot of things, but notably the applicant's experience in the operation of an ETC and its vehicles, the applicant's history of violations and or citations of alcohol laws, noise violations, Hub Nashville complaints, and other non-compliant behaviors, the ability of the applicant to comply with the laws and regulations, including the equipment and service to be furnished, and the applicant's financial responsibility and condition. So some 4 or 5 months ago, this commission considered all of that regarding Ms. Pizzatola and Nashville Party Barge, and she passed. And then in August of 22, she got her BYOB permits and completed all of her vehicle inspections. Over the course of her stewardship of Nashville Party Barge, they've served over 500,000 customers for over 60,000 rides without a single accident, without a single injury, without any infraction of note. They pay approximately $75,000 a year in taxes. The vehicles are maintained regularly, they're serviced regularly, they're insured, and the company carries an A+ Better Business rating. Okay, all that. So what happened? How did we get here? As I said, I don't dispute, for the purpose of this hearing, I don't dispute what was in the affidavit. And what I offer you is not an excuse. I offer you an explanation. I think Ms. Pizzatola, if you ask her, and you're welcome to, will tell you that she knows now this was wrong, but I think context is important. So Nashville Party Barge believed that other companies were providing alcohol on their tours. She based that on some of the websites she had viewed, Mint Julep Tours, Nashville Tractor, etc. She came up with an idea for something called mimosas and murals. The idea was that the party barge would go to various murals around town so you could take pictures of the murals, and they would provide mimosas. She called the beer board to ask how these other people were doing this. So whoever answered the phone at the beer board told her, we don't deal with champagne. We deal with beer. If you want to talk about champagne, you got to call the ABC. She called the ABC. ABC says that might be okay, but probably you need to go through a caterer because they got different licenses. If you can get it catered and get it all prepackaged, I think you can probably do it. She calls the caterer. The caterer says, well, if it's prepackaged and prepaid for, you don't really need to do anything. So Ms. Pizzatola followed, I guess, that advice. And let me be crystal clear. I am not saying that advice is correct. I am not saying that was the appropriate advice. That is not what I'm saying. What I am saying, though, and I think what Ms. Pizzatola's history and the history of this entire company is that these actions were done not in an effort to thumb their nose at this commission or the rules or the regulations, but were a mistake and an error in who she listened to, frankly. So she did this. Her husband is a veteran, as I've said. And this is the duty-free, the tax-free charge. He went to Fort Campbell, the duty-free shop, and bought champagne and brought it down there, and they prepackaged it up and provided it. When they were arrested, and this is evident in the warrants, they cooperated fully. She was open. They were transparent about what happened. None of this was done under false names or anything like that. They believed they were doing okay. Again, not saying that's correct, but that's what they did. Since Mr. Pizzatola was arrested in September of this year, they got in touch with the city and immediately stopped. And I think that's the most important thing. They talked to the city. The city said, you can't do this. They said, okay, we won't. They called the people who had pre-booked the Mimosas tour and refunded them the portion of their payment. Said, look, you're not getting mimosas from us. You're still welcome to go on the tour. It's going to be cheaper now. We welcome you to come on. Mr. Bob Pizzatola is no longer in charge of that. It's a family business, but he's no longer the guy in charge of all that. He has been removed from that portion of it completely. So I'm kind of back where I started. So what do we do from here? As I read these regulations, I think your options are pretty well unlimited. You can do nothing. You can fine them. You can put them on probation. You can suspend them. And then there's kind of the extreme measures of a revocation or non-renewal. Two things I want you to consider. The first consideration is that Nashville Party Barge is currently suspended. An emergency suspension was put in place 2 weeks ago. And I want to talk a little bit about that. I take issue with the emergency suspension. We didn't challenge it, but the issue I take with it is primarily is that emergency suspensions are reserved for issues of public safety. When there's a threat to public safety, then the director or the commission is allowed to come in and suspend you emergently without a hearing. I think a timeline reflects that there's not a public safety risk here. I think the city was aware shortly after the arrest in September. The notice was, the first notice was issued in October, no emergency hearing. We had to continue the hearing because Ms. Pizzatola had a medical condition that required a hospitalization. To the very next hearing, this hearing, and November 4th, some 2 months after the arrest and the knowledge by the city is when the, I guess, emergency suspension came down. So that just doesn't ring of a public safety concern. I will say, when we asked for the continuance, the Metro legal attorneys asked us to voluntarily cease until the next court date. We ultimately decided not to do that for two reasons. One reason is because we were in compliance. And the second reason is we had booked customers kind of months in advance. We didn't think it'd be fair to the customers to cancel their tour, especially when a hearing coming up. After the emergency suspension, what we could have done is gone to court and said some version of what I said and said we need a TRO to not enjoin us so we can kind of keep working because we're going to be damaged. We could have relied on the mailbox rule. We got the suspension notice via email on Friday afternoon. We could have said, well, really we can just say we have till Monday because of something called the mailbox rule. It gives you 3 days and you have to mail it. We didn't do that. Mr. Fan and I were in Denver At a conference, Ms. Pizzatola called us. We stepped out and talked to her, and we pulled our drivers off the street. We canceled tours, not only ongoing, but that day and tomorrow and the next day. Started to lay off employees, and we were harmed. Ms. Pizzatola calculates that from November 4th to today, it's a $20,000 loss in revenue. I've said a couple times, I'll say it one more time, we've laid off employees, and frankly, the reputational hit and the reviews we took will be harmful going forward. So I say all that, not so much to complain about the injunction because it's behind us. I mean, we can't go back or the suspension, we can't go back and unsuspend them and give them those rides back. But there is a punishment. And the second thing I would like for you to consider is that Nashville Party Barge and Susan Pizzatola, they are a proven commodity. But for this one-off incident of her husband, they have a sterling record. They have been in this business since the business started, and they have never misstepped in any meaningful way. This is who we want operating these trucks out there. These are the people we want to partner with the city to do these things. They're responsible, they're compliant, they're safe, they're transparent.
Mr. Farmer, I have a question.
Yes, sir.
So, we had our hearing back in the summer when we determined how many entertainment vehicles we would allow as permitted, and we came up with the number 39. Okay. And we had a number of companies come before us wanting way more than 39. And it was a very difficult, very long meeting. And you're right, we awarded Ms. Pizzatola's company 4.
Yes, sir.
And now what we have before us is what appears to be a clear violation of our rules as well as the laws of the state of Tennessee. And I would like for you to address this question.
Yes.
It's like, why shouldn't we revoke the permits we granted Ms. Pizzatola and hand them to a different company that also presented back in June and is operating lawfully but didn't get the number of permits that they hoped to obtain back in the summer?
Yes, sir. So a couple of reasons. First reason is, as I was just saying, I think Ms. Pizzatola and Nashville Party Barge, but for this incident, is proven. They're not new to this commission. They're not new to Mr. Fields. They have complied. They've invested financially, manpower, that they've been on board with these regulations, and they're committed to following them. Secondly, to that vein, they've taken the only corrective action they can take, and that they've stopped and gotten back in line. Was there a second part?
Well, why shouldn't we, based on what has occurred, shouldn't we revoke the permits we granted Ms. Pizzatola's company and give them to another company that is and has been in compliance?
Yeah, and so I think what you're talking about is in essence the death penalty to the Nashville Party Barge, and I think that's what I would say to that is, I read the range of punishments and I look through the regulations that talk about 1, 2, 3 strikes for driving violations and those sorts of things, and it seems to me revocation is for offenses such as DUIs, people getting hurt, sexual assaults, people running into pedestrians, those sorts of things, incidents that truly and significantly impact public safety. Ms. Pizzatola just simply didn't do any of those things. And so I think when you look at her history, you look at her investment, you look at what we have here and what she's done with it, I think the appropriate thing is to fashion an outcome where she gets to keep the four permits that she fought so hard for. She was one of the companies that sought more. That I don't think that's a secret. She sought 8, planned for 8, and got 4. So I think to take the 4 away from her based on what is admittedly a serious thing, but a one-off thing. Ms. Pizzatola isn't before this commission with regularity talking about things she's done wrong.
Mr. Farmer, going to interrupt you for a second. You're right.
I was finished.
Okay. Ms. Pizzatola is not new to this commission. You've asked us to consider her history.
Yes, sir.
And that she's not regularly before this commission for violations. She has other businesses that have been before this commission, doesn't she?
She has other businesses. I don't know if they've been before the commission for
Has she-
violations.
Tell me, should we be considering whether there have been other non-compliance violations that she's appeared before this commission?
I don't know if there have been. I don't know.
I
the
understand you
answer.
don't. I'm asking the question, when you ask us to consider her history, how far back should I go?
My understanding is that she has no history of noncompliance, so all the way.
Thank you.
You made mention during your remarks that Ms. Piscatola hasn't done this, Ms. Piscatola hasn't done that, and forgive me with the pronunciation of the name, I apologize. But Ms. Piscatola and Mr. Piscatola presumably are married,
Yes, sir.
and are they both owners of the company, correct?
No, that's not correct. She owns the company solely. The LLC is in her name. She's the sole member. Mr. Pizzatola was at the time the director of operations of the company.
Okay, and at this time, he was not an owner of the company when this incident occurred?
It's never been.
Okay.
That's correct.
Be unable to be an owner for any reason? Any criminal history or other background that would prohibit that?
No, sir. No, he has no criminal history beyond this. That's been certified by the TBI. And I do want to clarify, Commissioner McNally, one of her pedal taverns had an issue with either a second, I think it's a second bike operating pre-permit. And I was not aware of that.
It
but
was.
I am now aware of that.
Okay. There was, in fact, it was considered actually defiance of this commission when she was operating 2 pedal taverns, I think, when she was only supposed to be operating 1.
Yes, sir.
We had a lengthy hearing on that.
Could I ask a question? What was the outcome of that hearing? I don't think that was before my time.
Again, the minute book's not present. My memory of it is the commission reprimanded her, and I think there was a period of probation.
2 weeks. They shut me down for 2 weeks.
Well, I still, Mr. Farmer, I understand what you're saying, and I don't think it's as drastic of an analogy to refer to revocation as the death penalty. But what I am aware of is there's a tremendous amount of demand for the limited number of permits that this commission deemed would be a viable number at this time. And given what has occurred here and the serious nature of the acts, I do think that's something we should be considering as a commission, is revoking the permits. We're well aware of other companies wanting additional permits, have asked for additional permits. We've deferred that decision so we could hear this issue today regarding the complaints about the sale of the alcoholic beverages and the untaxed transportation of those beverages. And what I'm not hearing is a good reason to excuse that. And even through a suspension or probation, I mean, to me, that doesn't seem like enough.
I would submit it is. I would submit that a probation and a suspension is certainly enough. As I understand probation, it is a zero tolerance policy, and a suspension for some period of time certainly would, I guess, hammer the message home that Ms. Pizzatola is to be in strict compliance. I think the other side of it, though, is I think to take her from 4 permits to 0 permits, it just, to me, is just very harsh. Okay, I've talked about the history of this company. I've talked about the people that are employees. Talked about the taxes they've made, that the money she's put into getting her buses into compliance. I do believe it's a one-off, certainly this issue, and I think to go from and you don't like death penalty. I won't use death penalty, but the harshest sanction possible seems to me to be a bridge too far for not only what we have here, which is not appropriate and a violation of the rules, but is not a public safety issue. And Ms. Pizzatola's history, her commitment, the resources she's put in, and so forth.
I would like to also add that when Ms. Pizzatola went on suspension the last time, we did not have any more issues with her. It seemed to have been a corrective measure that she took to heart.
And that was 6 years ago?
Well, I didn't think it was that long ago, but...
It would have been in that range.
And I'm sorry that your client had not shared that with you, and I was catching a little bit off guard on that, but that's one of the reasons they get the old folks on the commission still. But I have a long memory about that particular contested hearing. Now, I have a couple other questions, though. Why didn't Ms. Pizzatola call Mr. Fields and ask, can I do this?
I mean, I think if we could...
That she called several other people around
She
the
called
city.
the-
The
she
place
called
she knows to
ABC.
call is Mr. Fields.
She called the ABC, and she called the beer board, and she called the caterer, and...
No, but I'm asking, why didn't she call
Well,
the
and-
people who
and-
issue the permit?
Yeah, and I'm answering the best I can, Your Honor. I think if you rewind the tape on any bad decision, there are always things you could have done, should have done. There wasn't a decision, you know what, I'm not going to call Mr. Fields. I'm going to avoid that. That just wasn't her calculus. I think it was more of a casual, hey, I heard this is going on, let me call the beer board. This is what they say, this is what they say. Okay, this makes sense to me.
When's Robert Pizzatola's court date next?
November 30th.
Okay. And the other thing I want to observe here is that Robert Pizzatola or the company certainly were being diabolical. They're going up to the base, they're buying untaxed alcohol, and they're coming down here and selling it, and they're trying to make a profit, a bigger profit than they would even be entitled to if they had complied with the law. It's not just what was going, but it was also this that brought the Detective Paul Davis and everybody else to do an undercover operation for $30,000 worth of alcohol being bought to avoid taxes. That's got some culpability of its own.
You want me to address that? Certainly.
That's my observations only, what I'm saying.
Certainly, and Mr. Pizzatola has been charged, and he has a court appearance, and the Department of Revenue may very well ultimately show up. But I do believe Mr. Pizzatola's charges will be diverted.
But was Mrs. Pizzatola involved in this?
No, not...
In a sinister plot to go up and try to avoid paying taxes on alcohol being sold in Tennessee?
She was aware that her husband was going to Fort Campbell. I think Mr. Pizzatola would swear up and down that she thought that was her and her husband's rights as veterans. They have a duty-free shop up there to do that.
To me, it might be some mitigation if Miss Pizzatola wasn't aware of what was happening. And I don't think I've heard that today yet.
I don't think I can be ignorant of what was happening. I'm not going to tell you that. I can tell you that I don't think she was aware of the granular detail of what was happening.
Just to follow up on that, Mr. Farmer.
Yes, sir.
I guess one of the questions that I have in light of the interstate nature of how the alcohol was acquired, and in terms of your comments about Ms. Pizzatola calling the ABC or calling the beer permit board, I guess the question that I have is what was the legal question that she was seeking when she was making those calls if we also have that interstate piece?
So the calls weren't related to the interstate piece. The question she wanted answered is, my competitors seem to be providing alcohol on the barges. How are they doing it? I want to provide mimosas. Like I said, the beer board said mimosas don't come to us; they go to the ABC. The ABC said maybe you can do it through a caterer if it's prepackaged and prepaid. I think to Ms. Pizzatola, the magic words were prepackaged and prepaid. And what she got from the ABC and the caterer is those are the magic words. So that's what she did: prepackaged and prepaid.
Was the caterer a licensed caterer
Yes,
who had an alcohol license?
I believe so. Yes.
Sell alcohol?
Yes, sir. Yes, sir.
Mr. Farmer, well, certainly Ms. Pizzatola, I mean, she should have been aware of this commission's rules, the Metro Council's rules governing entertainment vehicles. We spent a tremendous amount of time this past summer enacting the MTLC's rules, came up with a new definition of what an entertainment vehicle was versus a sightseeing vehicle. So it does beg the same question Mr. McNally had, is why didn't Ms. Pizzatola had any doubts as to what she could and couldn't do, why didn't she call the commission? Why didn't she call Mr. Fields' office? It rings hollow to me that she did not understand what she was doing was unlawful.
I don't know how to, I guess, ring that any truer for you, Your Honor. I think Ms. Pizzatola will tell you. She's telling me, I feel stupid. It's not what I should have done. It's not what I meant to do. Certainly, we're not up here claiming ignorance of the law. If that was the case, we'd be having a full-blown trial whether she was guilty or not. We understand that ignorance, that she's presumed to know and understand the rules. I think the reality for her is that she just simply didn't. And she talked to people who were, in her view, authorities. Maybe not Mr. Fields, but people from the beer board and from the ABC and from the caterer, people that were authorities and that knew the answers, and she relied on them. I think Ms. Pizzatola regrets that. She regrets that very much and regrets that to this day. I do know that she is committed and vowed not to be before this commission again, and that if any question comes up whatsoever, I imagine she will be at Mr. Fields' door.
Sounds like today you're kind of in that position where you're admitting responsibility for the acts, and you're coming before us posing a disposition that might be favorable to your client or not as bad as could happen to your client. What do you think about the idea of, she has 4 permits, right?
Yes, sir.
What about suspending 2 of the permits and letting her be on probation on the other 2 permits?
I think that will be, I would understand that. I would understand that.
I know that one of our members here feels like they probably ought to all be suspended. That may be the majority.
Sorry, Commissioner McNally, but when you say suspended, do you mean temporarily?
No,
You mean revoked?
I'm sorry.
Yeah, I want to clarify that.
Revoke 2 of them and leave 2 in business.
I think certainly that would cause a tremendous hardship. I would say revoking 2 is better than revoking 0. I said that wrong. Revoking 2 is better than revoking 4. And certainly, I think that's just a mathematical fact. I think I will propose some sort of suspension for all 4. I think that would kind of give every party what they need, and then that's kind of to impress upon her the seriousness of this without kind of throwing away the 7+ years she's had of investment in operations.
What is the value of 1 permit in terms of revenue to?
The value of 1 permit.
Over a year's period of time.
The value of 1 vehicle?
Mm-hmm.
1 permit.
Revenue.
In sales?
That gross?
Yes, sir.
Okay.
This is the family's livelihood. You know, they're not living the high life off this, but it is their livelihood.
Even more reason why you wouldn't go ahead and call the executive director of the commission to say, hey, can I do this?
So am I right to understand that their Nashville Party Barge is only operating 4 vehicles at this time?
We're not operating at all right now. because we're
But
suspended.
prior to the
Yes, sir.
suspension, okay.
Okay.
Thank you, Mr. Farmer.
I'll be right here if there's more questions.
Mr. Chair,
Yes.
may I interpose a clarification, I guess? Okay, and this may be a question for Ms. Pizzatola's counsel, but yeah, potentially. But the matters before this commission today are actually twofold. One was the due process hearing that was intended to follow up the temporary suspension. Section 090C says if the holder commits an act in violation of the criminal laws of the United States or the state of Tennessee code and the MTLC director determines that the holder poses a threat to the public safety, the MTLC director may enact an emergency suspension of the holder's certificate. Then based on the history that Mr. Farmer shared with you, it was scheduled for the October 27 meeting, and then because of Ms. Pizzatola's medical procedure, they requested a continuance but declined to agree to suspend services voluntarily during the interim. And so it was at that point that Mr. Fields did, in fact, issue a letter suspending them. And the language was because of the serious nature of the offenses alleged in the attached, which I find to be credible, and the attached was the warrant that you all have before you, and the serious degree of disregard for the law shown in the exercise of judgment by the Party Barge's agent, I am concerned that public safety may be jeopardized by Nashville Party Barge continuing to operate. So that was the basis for that emergency suspension. So Mr. Fields only has the authority to do that emergency suspension on a temporary basis. Then that has to come before you all to decide if there was actually adequate cause for that issuance. Then the second issue is the discipline for the violation in the first place. Do you find that a violation occurred, and what discipline do you find to be appropriate for that? So I guess my question to Mr. Farmer would be, are they sort of like waiving the issue of the emergency suspension, or do they still want the commission to consider that?
Well, that's what I was saying, you know. I mean, we can't unwind it and unsuspend us and go back in time. So I think it's frankly moot. I think they were suspended, they complied with the suspension, and now we're here to decide the substantive issue.
All right, so it sounds like we're down to just 2 matters then. One, first finding whether there was a violation. 2, if there is a violation, what the disposition should be. So there's an agreement that there was adequate cause for the emergency suspension by the executive director.
Mr. McNally asked if you.
No, I'm just
No,
making a-
he
I'm
made a
just-
statement.
I'm making a statement.
I was with it.
I'm making a statement or finding from what I hear here today that there was adequate cause for the emergency suspension by the executive director of the.
The commission does not act except by motion.
So, I'd make a motion that there is adequate proof before us that there's been violations by Party Barge, which exactly was it, these 2 here.
Are you trying to make a motion that there was sufficient grounds to suspend, for Mr. Fields to suspend? We needed to make a motion to that finding. We need to make a motion.
I make a motion that there was adequate cause or adequate grounds for the Executive Director of the Transportation Licensing Commission to engage in emergency suspension party barge.
Motion seconded.
All those in favor?
Aye.
Motion passes.
Now, I think it's been conceded by the parties, or by Party Barge, that they have violated, they have 2 violations here, and I would make a motion that we find that that there's been adequate grounds here to show a violation of, hopefully I get these correct, 677.240 and 677.090. That being the violation of a state law and selling alcohol in an ET.
Yes, those are the overriding sections. Do you want to add a subsection A, B, or C, or D?
Go with A.
I think that's an excellent choice. A is a certificate holder or driver commits an offense if he or she provides beer, ale, wine, or other alcoholic beverages to a passenger for a fee or is part of the passenger transport service.
Seems to be supported by the affidavits to the warrants, so.
Second.
Seconded.
All those in favor?
Aye.
Motion passes. Now that leaves us with the issue of what type of sanction to impose for violation. We can revoke Ms. Pizzatola's permits. We can suspend those permits. We can place the company on probation. Under our authority under 6.77.090.
I'm ready to make a motion.
All right.
We'll start the discussion. I move that we revoke all 4 licenses for the violation of the rules.
Discussion?
Second for
All right.
I would be curious relative to the past history of the commission. Have there been ever multi-year suspensions? A 3 or a 5-year suspension?
Not since I've been on the commission, but we haven't had, not since I've been on, excuse me, I thought my mic was off. Not since I've been on the commission, but we also haven't had something this egregious in terms of
So
scope.
I can address that, I think, Mr. Chair, if that's okay.
Yeah.
So what the company has is a
1 year.
is certificate for 1 year, exactly. So it would be kind of like speculative to have a multi-year suspension. So a revocation is a revocation of that 1 year.
It's also difficult once they have a license to unwind the license.
Yes. Once you have a certificate, you are eligible to renew annually. And generally, they would be renewed unless there was some cause not to.
And what I guess had been thinking about a little bit, to articulate a little bit better, is it would remove, a longer-term suspension would remove the ability to reapply for a short period of time, and it would also not necessarily put additional licenses back out on the street for other vendors. But it wouldn't also, it would give her an ability to come back well in the future.
I don't see how we could suspend somebody when they have to apply for renewal after a
Annually.
while, yeah.
Yeah.
Or, I mean, we suspend beyond the renewal period of time, so.
090A says, a certificate issued under the provisions of this chapter may be revoked, suspended, placed on probation, otherwise restricted or not renewed by the MTLC if the holder thereof has, and then among the list of things is either violated MTLC's rules or violated state law, which we have already found they have.
So the holder would have an ability to reapply in January because the holder.
Yes, technically, the holder would have the ability to reapply at the next application deadline for the following year, but you all, in granting, it would be, it's essentially they would be in the position of asking for a new permit. And so you all would also be allowed to consider their past history of compliance in deciding whether to award them permits at that time.
What is the typical effect of probation on a license's ability to be renewed at the next cycle?
I'm not sure that we've ever had an example of that. Billy and I were brainstorming, trying to remember if either of us knew of a revocation that had actually ever occurred. And all we could think of is that in some of the more serious cases, people surrendered their certificates rather than be subjected to the disciplinary process. So, I mean, the most serious I think I've ever seen was maybe a 30-day suspension. I've certainly seen probation for 6 months to a year. But you know, obviously that would be if there's any further violations during that period, then it would be revoked or suspended.
I would concur that, from my memory, is that I think we've had 30-day suspensions, and then we've followed with long-term probations with conditions as well as supervision. For purposes of discussion on the motion, I'm not inclined to wipe them out completely, which was revoking all 4 permits would do that. I'm inclined that there be some severe punishment because of what I consider the most culpable part, and that is going up there trying to avoid taxes, and then selling it on the bars to make a profit. I'm curious, are there other ETs that are actually serving alcoholic beverages?
I think there may be under the beer permit. Or is that just?
The way it's written is you must have a permit from the beer board and then follow the regulations that are there. They have a couple of different paths they have. But as far as alcohol, there is, you know, as we see it, there's not a provision for alcohol because the beer board has no authority over alcohol. Right. They only have authority over beer. So, you know, if we were to find a company that was dealing with alcohol, that's beyond what the beer board has authority over.
Correct, and the beer board is Metro, and the Alcoholic Beverage Commission is state. So the consumption of the higher percentage of alcohol beverages is governed by state law.
I was more inclined to the idea of revoking 2 of them and letting them have the other 2, but put them under probation. On the other hand, we could suspend them, all 4, for a period of time, and then or revoke 2 and suspend the other 2 for a period of time so they could so Ms. Pizzatola could get back into business around the summertime.
So I guess the questions that I have here, and forgive me for being so new, in terms of the current license period, right? For Ms. Pizzatola, when did it begin and when is it set to end?
Her permit was approved by the commission in June. It will end on April 30th as all according to 677 is passed by the Metro Council. We'll begin the renewals on April the 1st, and all permits that are not renewed by April 30th are void.
Okay, so on April 1st, regardless for these 4 permits, she would have to file renewal applications.
Actually, I'm going to be asking you some questions about that a little bit later about making a change. Currently, it would be making an application by June the 10th. We're going to ask you to delay the annual hearing of the commission for ETs till April, and which would change the deadline to March 13th.
Okay.
June 10th.
I'm sorry?
He meant January.
Yep.
He did.
January 10th, I'm sorry, January 10th. I'm sorry. I was, yes, January 10th
We
is
were
the
locked in.
it's the current deadline.
Okay. Yeah, I think I kind of fall along the lines of Commissioner McNally here with this. I think taking away all 4 of the permits is pretty drastic. I understand the reasoning why, but I'm inclined to have a mix of probation and then some measure of suspension, whether that's 2 or 1. I can be talked either way, but for me, I think, you know, with the statement of $200,000 over a period of a year, that's a significant amount of revenue, and these are significant charges that we have here in front of us. But all the same, that's kind of where I'm leaning.
How much is invested in each carriage?
According to which vehicle it is. The cheapest vehicle I have is about $45,000. The most expensive is about $80,000.
Thank you.
So a follow-up to that, I heard your council represent that, I thought I heard you spent $105,000. Is that to enclose two or?
Those were all new vehicles.
Okay.
When the council and the board and the regulations came out about enclosure, I jumped and bought enclosed vehicles. And I spent an additional about another $20,000 enclosing the ones I have.
So all 4 of your vehicles are currently enclosed?
Yes, sir.
Mr. McNally, would you like to make a motion?
I think there's a motion on the table.
Oh.
Yeah.
Second.
Thank you for that reminder. All those in favor of Mr. Rogers' motion?
Aye.
Any nays?
Nay.
Nay.
Motion fails.
Could I make sure I know who was nays?
Me.
Commissioner, when you were using the word suspension, did you mean suspension or revoke? And there being a difference. Commissioner Relaford?
Oh, when I was
Sorry.
here, I just started today, y'all. Okay. I guess what I was saying is I may be misunderstanding given the punishments that we can levy here between probation, suspension, and revocation. Revocation, in my mind, is a permanent taking away of the permit. Suspension would be for a set period of time, right? And that's why I wanted to know the renewal date to determine, okay, if we set a period of time for a suspension, what would be an adequate period of time that we would if we suspended, say, 2 of the licenses and put 2 of them on probation, or permits rather.
Well, I've got something creative, I think. I'm thinking we do suspensions of all 4 and stagger them. Suspend one for, say, 30 days, another one for 90 days, another one for 120, and another one for 180. That's severe punishment because you won't be operating one of them for 6 months. And I'm open to suggestions about that range, but I was thinking maybe stagger it so that I remember Judge Fishburne saying one time that if a DUI person had to go back to jail every weekend, they would certainly remember not to drink during the rest of the week, not to drink and drive during the rest of the week. And I think if one of the vehicles is always on suspension for a long period of time, that this company will be reminded never, never, ever again violate and call Mr. Fields before you do anything. But that's a thought.
Can you restate that, please?
Yes. I was thinking that we would suspend all 4 vehicles and stagger the dates for when they would come off the suspension. And 1 for 30, 1 for 60, 1 for 120, and 1 for 180. If I got that right, that would be 1 month, 3 months, 4 months, and 6 months, right?
1 month,
2
2
months.
months,
2 months,
4
okay.
months, and 6 months.
Yeah, okay. So,
Can I ask a point of order here? How can you, if the license is only for a year, up to whatever date we're doing it, how can you suspend beyond the time of that license?
you're
How can you
right,
suspend
you're
a
right,
license that in essence they don't have? Is that?
see, this is November.
Is that
April
more
30th.
than 6 months from now? Or
Would
less
be
than 6 months from
Yes.
now?
January,
Okay,
5.5.
yeah.
March, April.
Yeah,
All right,
that's true.
So 30, 60, 90, and 120.
Or you could just say April 30th
Or April 30th, yeah.
for the final one.
Yeah. All right, 30, 60, 90, and April 30th. So one of them doesn't come back on. It's basically almost like revoking it, but.
Any further discussion?
Would 30 include the time period which I have suspended within that first 30?
No, today. So what did I say, 30, 60, 90, and April 30th?
So that third permit would truly only probably be operative for what, about a month before the renewal period?
3 months from now, that would be December, January, February. Yeah,
Yeah.
be 1 month before the renewal. All right, so I'm just going to make it into a motion. I make a motion that we would suspend party barges for permits with them coming back with the suspensions ending on one unit after 30 days, the second unit after 60 days, the third unit after 90 days, and the fourth one doesn't come back till April 30th.
Is there a second?
Before we get to the second, one question for legal. In terms of the permit review process that will occur next year, given the nature of this punishment being a suspension, they would still be, after those suspensions were up, be the holders of those permits. Is that correct?
Correct.
And they would then need to reapply for them, but that disciplinary record would be.
They would need to reapply, but it would be a renewal. It would not be a new application.
Okay.
So can I continue that? So would we be able to take this action under advisement when we make that decision? I mean, past behavior, would that be something we consider?
So if you're renewing, if you're renewing, let me look it up. Let me make sure. But I think if you're doing it from a perspective of a new application, you have more flexibility to take past disciplinary history into account than you do from the perspective of just a renewal. But let me look it up.
Okay, that's what I thought, and that's one reason I wanted to revoke. If she wants to come back and reapply, considering these facts.
I think there's two sections that would be pertinent.
But you're in essence saying
This is the finding on the root.
she won't have to apply for a new license. She can reapply for one she'll continue to hold.
Okay, Mr. Fields has found the relevant provisions, so I'll read them to y'all. 677-030A, if the MTLC finds that further or additional, so this is for new permits. If the MTLC finds that further or additional entertainment transportation vehicle service in the metropolitan government area is required by the public convenience and necessity, and the applicant is fit, willing, and able to provide such service and to conform to the provisions of this chapter and the rules promulgated by the MTLC may issue a certificate of public convenience and necessity stating the name and address of the applicant, the number of vehicles authorized upon such certificate, and the date of issuance. And then for the renewal, it's under 677-060, and it says all certificates issued under the provisions of this chapter shall expire on April 30 of the year following the date on which the certificate was issued. All certificates may be renewed by the MTLC director for each successive year between April 1 and April 30 of each year. If the applicant meets all applicable standards for renewal as established by the MTLC, a renewal fee for each certificate and other licensing fees shall be charged at the annual renewal for the certificate. So it sounds like maybe, I don't know to what extent in our regulations, if at all, it does specify any standards for renewal. We don't think it does.
I think it's different. I think that if it's a new permit,
you have a higher level of review than a renewal permit, but I think that it's a gray area within the regulations. I think a renewal is supposed to be more of a, here's my money, let's renew, versus a new applicant, you're looking at all the qualifications, you're looking at the applicant, you're sort of doing more of a deeper dive.
I do think, though, that if there was like a basis for concern about I feel like, and maybe this would have to be something that you all would adopt in the form of regulations, but I do feel like if you had concerns about the fitness of the applicant's character and ability to comply with the law and rules, then you probably could take that into consideration at the time of a renewal. But
Could add it as part of your motion, perhaps.
Well, it does, in the renewal statute, talk about if they meet our standards, the commission standards.
in the renewal?
Yes, it does. Yeah.
So the question then becomes, are those standards adopted by the MTLC? And the question is that your current regulations on ETs don't specify any such standards that we're aware of. But not to say that you couldn't amend the rules and adopt some, but to date, we don't believe you have.
I mean, typically the renewals wouldn't come before you, a new application.
Right. Billy would look at those.
Director may, which means that means I would have the option to bring it back to the commission, which, based on your business this year, it's my impression you want to see them next year. So I intend to bring all applications to this commission at the annual meeting.
In the motion, you could specify that. Yeah, I was just gonna say, in the motion, we could amend the motion to specify that the commission is
Mr.
asking.
Relaford, would you make sure your mic's on?
Am I not on? Am I on now?
Yes.
We're back in business. What I was gonna say was, in the motion, we could amend it to state that, the director will bring the renewal applications to the commission. Thus, they would be properly before us at the renewal period, and we'd still have the measure of relief that you're discussing.
All right, can I amend my motion?
Yes.
All right, I'm going to amend my motion that all 4 units of party barge vehicles are suspended. The suspensions will lift on the first one after 30 days, after the second one after 60 days, the third one after 90 days, and the fourth one will be on April 30th. However, as a part of the renewal process, party barge will show complete compliance with the standards of this commission and all other rules and regulations that are in force, including the laws of the state of Tennessee, and that Mr. Fields will bring the renewal applications to the commission before any action's taken on them.
Seconded.
Any further discussion?
Yes. In essence, we're making this decision today, and if they come back and ask for renewal, they're going to say, well, we've already served our sentence. And I can't see how we can look at that as a new application. So I'd like to make a motion to amend your motion to revoke, completely revoke 2 licenses, suspend one of the other ones for 30 days, the other one for 60 days. And then they can reapply, let me make sure, they can reapply for the other 2 licenses, correct? And then we can deal with it, those 2 licenses separately and from a new start, essentially.
Second, to enable discussion?
Yes.
And from a discussion standpoint, a question, did want to ask one question relative to, thank you, over here, relative to public safety and alcohol serving. Who's checked driver's licenses? Who served the alcohol?
We have someone.
Was there a licensed bartender?
It depends which kind of vehicle.
In this
instance.
yes. I mean, you could either ask them to speak to that, or we do have a special agent here who can, if they'll just submit who was on the vehicle, who poured the alcohol,
That's an ABC violation.
It's a,
Without a license.
please.
You want me to answer?
Sure.
It was prepackaged.
So,
It
so there's,
it wasn't poured on the vehicle, is what I'm saying.
right, but let's just say I was 19 years old and I bought a ticket to come on this bus.
Yeah.
Or if I was 25 and I had 17 prepackaged, I overconsumed.
So you were allowed two, is it two? Two cups. And there was a verification of age process when you signed up online.
From someone with a license to be able to distribute alcohol?
I don't know the answer.
From a bartender?
No, I think you, yeah.
Could I have a question? You said it was prepackaged. Prepackaged by who?
I believe Party Barge. Yes, sir.
Then you didn't purchase it prepackaged. You were in essence operating a bar. Is the agent you were talking about ABC? You know what I mean?
He's TABC. He's still here. And he could speak to how he found it, if that makes.
Well, I'd like to know the way in which they were operating. I mean, they were opening the bottles, pouring them. It doesn't matter if it's prepackaged or not. Isn't that operating as an unlicensed bar?
Yes, sir. To our understanding, they were operating as an unlicensed bar because they don't have a liquor license with us.
Sir, just for the record, could you state your
Yes,
name?
sir. My name is Thornton Voms. I'm a TAB special agent with Tennessee Alcohol Beverage Commission. Nice to meet y'all.
And I think you may have the same issue we do. You can't discipline them because they're not licensed with you, correct?
Yes, sir. That's why we have to go to the legal side of ours, is
Right.
just him with state law.
It's a criminal violation
Yes, sir, it's
to
criminal
operate
violation.
a bar without a license.
Yes, sir. If they had a license with us, we would just cite them regulatory versus the state law.
But what we're doing here.
Yes, sir.
Okay. And is it okay to, yeah, I'll ask. Are you gonna you're gonna push criminal charges?
To my understanding, with the DA's office, I think they're trying to push the criminal charges. I don't know because they really haven't, I guess, relayed the messages to me per se. But my attorney through TABC, it seems like he is willing to plead to the charges. It's just I don't know what the final decision
So
will
that's
be.
up to the DA?
Yes, sir.
Okay.
If you could just, I'm sorry, Special Agent, I think the question was, how is the alcohol served?
So
Yeah, go ahead.
Sorry. So when the undercover agents entered the party bus or got on the bus, they received red Solo cups, and they said the alcoholic beverage was already in the cups for them. And so one of the agents drunk it just to make sure they had to taste the alcoholic beverage to make sure it is in fact booze because it could be malt beverages or beer. So they tasted the alcohol and it was mixed mimosa champagne.
They were operating a bar.
Yes, sir. So to speak.
Well, not so to speak.
Somebody mixed it in this container. They knowingly broke the law.
Well, let me add this, because it looks like the effect of what Mr. McNally has proposed in his motion is that one of the carriages is getting revoked. He's called it suspension, but it's suspension for the remainder of the 1-year period, at which time Ms. Pizzatola would seek a renewal of that. But there's nothing preventing Ms. Pizzatola from seeking a new permit for the new year. So the net result is that one carriage is revoked for the year. And Mr. Rogers, you're asking for 2 to be revoked and then 2 suspended for 30 days, and then after 30 days, 1 comes off suspension, correct?
Yes.
I'm just trying to find some overlap here on the 2, and it seems like it's really just the revocation of 1 versus 2.
Well,
Except it's not really a revocation if it's suspended and then is renewed as opposed to coming in as a new application.
And
That's really the
yeah,
difference.
and Mr. Roger makes a good point that I can see Mr. Farmer standing in front of us and saying we should renew her application because she has served her time, so to speak. And so I'm going to try one more motion here.
One more amendment.
If I can. Is that okay?
Yes.
All right. I'm going to make a motion that three of Party Barge's units are suspended. The fourth one is revoked. The permit is revoked, and that the suspensions would be 30, 60, and 90 days for the three. That the first one would come off suspension after 30, the second one would come off suspension after 60, and the third one come off of suspension after 90 days, and the fourth one is revoked.
Is there a second?
Second.
Any further discussion?
I want to make sure no one wants to amend the motion. Revoke all four.
Mr. Chairman, let me just make sure.
We had two.
And then we had an amendment to the
Proposed
motion,
amendment.
and there's no action on those particular two, so they're still saying that now we have a third one.
Yeah.
If
Am I allowed to strike my motion?
You can withdraw it
you
if
can
your
withdraw-
second
withdraw-
agrees to
withdraw your
withdraw it.
motion, he can withdraw his motion to amend your motion,
All right, I have withdrawn my original motion to be substituted by the latest one.
which would automatically withdraw his motion as an amendment to that motion.
Yes.
If we vote for his amendment, which we haven't done yet.
We have not.
Correct.
His motion.
Can I ask another legal question here?
Yes.
If there is subsequent criminal action against the licensee, can we then come back to this process and take that into account?
Yes, that would constitute a separate violation of 090 that would be subject to discipline independently.
Because now there would be a conviction, not just a charge.
Okay, so we're relying on the DA, I guess, which I don't, well.
So, I mean, you all have ability to otherwise restrict it, which I think does give you some leeway to add some other conditions if you want to. Right now, what ETs can generally do, the non-seated sightseeing vehicle type, is that they can go to the beer board and they can get two different types of permits from the beer board. One is for BYOB, to allow BYOB to happen on their vehicles, and one is like actually to kind of be a bartender type situation where you'd have a licensed bartender checking IDs and serving the alcohol. And the alcohol would be like of the alcoholic content of beer, not of the higher alcoholic content of liquor. You could, for example, I think, prohibit them from utilizing any of those sorts of alcohol during the period of the suspension or the period of up until April 30th. You could also say, like, if you're putting them on probation after they come off of suspension, you can put them on probation and say, like, if another violation of the code occurs or if any alcohol is served, whether it's a violation of state law or not, that would revoke their suspension or probation. And so you can add more conditions if you want to. It's completely at your discretion.
Well, Ms. Costonis, you have just complicated things even more. I think under the circumstances of this case, I would add to my motion that the remaining 3 units that are on suspension would also be, that the company would be on probation, and one of the conditions of probation is they're prohibited from having alcoholic beverages on their units.
How long is the probation?
Till April 30th of 2023.
All right, Mr. Rogers, did you withdraw your original motion?
No.
Was that a?
What was that motion?
No, I didn't withdraw anything.
He made a motion to amend your original motion, which you withdrew yours.
Yeah.
So
His is
my motion is still on the table.
to revoke 2 and suspend 1 for, 2 for 30 days and 1 for 60 days.
So it wasn't an amendment. I just want to make sure we're clear on the record. So there was a motion and seconded, and then there was a separate motion.
And I made proposed an amendment to his motion.
Right, but when his
And then
motion
he
was
withdrew his.
withdrawn,
So you can't amend a withdrawn motion, so you'd need a new motion.
So we're back at zero.
well, Mr. McNally's motion is on the table, I think.
Okay, yeah. And so is my proposed amendment to his motion.
No, because that was the proposed amendment to the prior motion. You can now move for an amendment if you wish to.
Okay. This is complicated.
So the motion on the table right now from Mr. McNally, which has been seconded by Mr. Relaford, is to revoke one permit and suspend the other 3 for 30 days, 2 for 60 days, and then just 1 for 90 days. And then also that when she is able to operate post-suspension, that her company be on probation for the entire remainder of the term and not be permitted to serve alcohol.
Okay.
Correct.
Okay, I want to offer an amendment to that motion, which is essentially the one I made before, is that we revoke 2 licenses, and we suspend one for 60 days and the second one for 90 days, with the provision, well, it's already in your motion. So,
Is there a second regarding Mr. Rogers' amendment?
Second.
Any further discussion? Is it proper to call Mr. Rogers' motion for a vote at this time? Just to double check.
You vote on the amendment first,
Okay.
and then on the bill
Thank
if
you.
it gets amended.
All right, all those in favor of Mr. Rogers' amended motion?
aye.
And nays?
Nay.
Motion passes 4-2.
I call the question on the original motion, which is yours. Now is amended by me, correct?
Your
That makes sense.
motion,
Passed.
your motion passed.
No.
So that was just amending
Right.
Oh,
so now we have to vote on the motion as amended.
thank you.
So
All
I'm
right.
calling the question.
Thank you, Mr. Rogers. All those in favor?
Aye. Sorry.
Mr. Powell, did you vote aye?
This is on, I'm confused.
We just passed Mr. Rogers' motion to amend the motion to revoke 2 permits and suspend 2 for 60 days and 1 for 90 days. With probation for the remainder of the term and not be able to serve alcohol through April 30th. That passed, and now we're voting on that substantive amendment. And on the bill as amended, yeah, subject to what I just described.
Revoking 2, suspending 2, you said suspending 2 for 60 days?
Right.
30 and 90 days.
I thought it was 60.
So that's 5.
No. Revoke 2.
Yes, sir.
Suspend 1 for 60 days and the 4th for 90 days.
Okay.
And so that's what we're voting on is Commissioner McNally's original motion as amended by my amendment. And that includes the probation with, that doesn't allow any alcohol to be sold.
That's the main section.
Right. The amendment.
His motion,
My motion has been amended, and now we're voting on the motion as amended.
correct. And the part, you've amended the section on the vehicles, then the part that will be added in, and then the part that will remain on the original motion is the probation and that portion. We unraveled. Got it.
Aye.
All right. And nays, any nays?
Nay.
All right, motion passes 4-2. All right, that concludes that hearing regarding Nashville Party Barge. Next, we have a disciplinary hearing regarding Tamina Qureshi against Apex Parking Company. Mr. Fields, I do need to excuse myself for the remainder of the meeting. I'll turn things over to Mr. McNally.
Unfortunately, Mr. Fields also must excuse.
Wait a minute. 1, 2, 3, 4. 1, 2, 3, 4, 5. We're still, as long as we maintain 5.
I have to go pick up a child.
The reporter's joining.
We will lose quorum.
Well,
Move we adjourn.
but
We can't vote on adjournment if we don't have a quorum.
Okay.
we would need a
Let me-
motion to move
wait,
the.
wait.
5 is
Yeah.
a quorum, right, of 9?
They have 9, so we have to have 5. And Mr. Rutherford has to leave, so we've got Mr.
Oh.
Powell, Mr.
Four
McNally,
is not
Mr.
a
Rogers, and
quorum.
Mr. Westlake. Okay, it just as a point of order before we, okay, so what we would do then is defer the complaint, the 2 complaints would have to be deferred then to the December meeting. The review of the vehicle request would go as well as the wrecker. The only thing, if I could,
Is the review of the vehicle request a quick one?
we're gonna have to show you some pictures and things. I think y'all have a discussion. If I could then, let me, under other business, I was gonna ask if you would consider changing your annual calendar for 2023. Currently, you have February for your annual meeting on entertainment transport.
These 2 ladies are whispering that theirs is quick. But
Look,
Mr. Chairman, you're the complainants, correct? Okay. You have something that would be pertinent to this hearing?
No, the one, they're next.
I understand we're gonna lose quorum and we've set the annual meeting for entertainment, transportation, application, consideration, certificates, public convenience, necessity for February with a deadline in January to file. I'd like to ask you to move the ET annual meeting to April the 27th and establish March the 13th, which is approximately 45 days at noon on March as the deadline for the application process.
So moved.
Second.
all those in favor say aye.
Aye.
Any nays? All right, that's done. Do we have a motion to, or I guess we don't need a motion to defer things, do we?
We certainly could defer it. I think it'll automatically roll over,
Yeah.
and I placed it on the agenda for you, so I just placed it on the next agenda.
And I'll take the people who brought the complaints and everything here in just a minute and explain to them what we're doing, okay? All right. I know some people have got to go for children, so. All right.
Yeah, you certainly can, without a quorum, you can advise
That's
the
always-
public what's happened.
All right, folks, we still have some other business on today's agenda. Unfortunately, there's some matters that have to be taken care of by several of the commissioners, and we do not have a quorum, so we cannot vote on any actions. I apologize for the inconvenience. As you can see, we've been rather busy today with some lengthy, delicate, and difficult matters. Mr. Fields, let's see if we can call this. Who is Tamina, is it Karish against Apex Parking? Bye. I'm sorry. I hope you understand. Can you come back next month?
I will try.
All right, Mr. Fields, what's our next meeting? What date?
December the 8th.
December the 8th.
Can I ask a question? And I realize we can't reach a decision about an issue like this. Can we hear the evidence and then make a decision at a later date?
I think that's awkward because the people,
Not without
once you have a group that's going to vote on it, you need to have a quorum.
To hear
And
it.
if they didn't hear the evidence, then
I mean, they wouldn't do what I told them.
And I
Well, I
also
think we know
don't
the
think
answer
the Apex showed up. I don't know if there's anybody.
Apex is not here? Oh, okay, they're there. All right. All right. Do you live in Nashville?
I do live in Nashville. I
Okay.
can come back.
Is this a witness with you?
Yes, she was with me at the time.
All right, I'm so sorry, but I hope you'll come back December 8th. If that turns out to be inconvenient, please contact
We could go to
Mr.
January.
Fields at the office, and we may be able to move it to January. We meet once a month, so.
Okay, all right. Thank you very much, I appreciate
We
it.
also have
Okay.
Mr. Fitzpatrick with a complaint against volunteer taxi cab.
Mr. Fitzpatrick, are you in the room? He's not here, Mr. Fields.
Well, he,
Well, let's defer it 1 month anyway, okay?
and then your final
You
is,
can't make him, you can't vote
You're-
on it anyway.
Yeah.
your final is a wrecker, and it, again, the commission has to take action on that in order for it to
Is
operate.
this a new driver
Yes.
application?
It's a new company application.
New company, okay. All right, and we've taken care of other business. Is there a motion to adjourn?
Second.
All in favor, say aye. All right.
It's the only motion you can make without a quorum.
It is.
Oh, I was gonna ask, do we have to keep meeting?
You got a thing I can do I wouldn't expect?
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.